Good afternoon. I'm Eric Way, Director of Client Relationships at LexisNexis Canada. Welcome and thank you for joining us for this, the third in our panel discussion series, Technology and Litigation, Shifting Paradigms. Today, we will look at the adoption of technology by our Canadian courts, an area where so much has changed over the past 2 years. We have seen more advancement in the areas of virtual hearings and electronic documents, for example, than we had seen over the past 2 decades. Justice David Brown of the Ontario Court of Appeal, amongst others, has described this as the pandemic's silver lining, a once-in-a-100-year opportunity to accelerate innovation and technology adoption in our Canadian courts. I'm looking forward today to speaking with our panel of judges from across the country, each of whom will share their perspective and experience from their courts. Now, as I introduce our panel, I invite you in the audience to respond to a quick poll question just to get things started. And the question is, how has the adoption of technology by the courts since 2020 changed your experience with the judicial process? And we ask you to answer on a spectrum from better to worse to about the same. And now to introduce our panelists, with us today are the Honorable Pamela Williams, Chief Judge of the Provincial and Family Courts of Nova Scotia. Chief Judge Williams was appointed to the Provincial and Family Courts of Nova Scotia in 2003. In 2011, she was appointed Associate Chief Judge of the Provincial and Family Court, and 2 years later, in 2013, she was appointed Chief Judge of the Provincial and Family Court of Nova Scotia. Prior to her appointment, she was a staff lawyer with Nova Scotia Legal Aid for nearly 20 years, representing adults and youth in the areas of family and criminal law. Welcome, Chief Judge Williams. Also with us today is the Honorable Justice Joseph Kenkel of the Ontario Court of Justice. Justice Kenkel was appointed to the Ontario Court of Justice in 2000 and appointed as a technology advisor to the court in 2021. In addition to presiding, he spends half his time on technology projects related to the Ontario Court's digital transformation. For more than 20 years, he has been part of every provincial court technology project, and he has been a member of the Chief Justice's IT Committee, which oversees court technology issues for all 3 levels of court in the province since the year 2000. Thank you, Justice Kenkel. Finally, we have with us the Honorable Justice April Grosse of the Court of Queen's Bench of Alberta in Calgary. Justice Grosse has been a Justice of the Court of Queen's Bench since May of 2018. She hears applications and matters in family, criminal, and civil law. She is a member of the Family Resolution and Commercial Duty roster and serves as co-chair of the court's Judicial Management and Technology Committee. Prior to joining the court, she served as law clerk to the Honorable Justice John Sapinka and the Honorable Justice Ian Binney at the Supreme Court of Canada. She then maintained a diverse litigation practice as a partner at Bennett Jones, with particular experience in commercial law, estates, policing, and administrative law matters. Welcome, Justice Grosse. So before we get the conversation started, maybe we can take a quick peek at the poll results. We got those?
Yes.
And so what we see here is 51% of the audience has said the experience is better than before. And in terms of the worse, we're seeing only a combined 10%. So Chief Judge Williams, why don't we start there, if you want to react to that, or also just give us an overview of high level of your own experience with technology within your court over the past 3 years.
Well, thank you, Eric, and thank you for the opportunity. Somewhat surprised by the poll, I would say. I have to start out by saying I'm not an expert. There are colleagues on my court that are equally or more adept at technology issues, but there have been certainly a lot of changes in Nova Scotia with the pandemic. We've had an all courts technology committee for many, many years. And when I was a new judge, I was part of that. But since the pandemic, we've developed 2 or 3 new committees to really deal with issues of getting virtual court off the ground. So there's an all courts virtual court committee comprising the provincial court, the Superior Court, and the Court of Appeal. And then at the provincial court level, we have our own virtual court committee. So what I would say is that in the provincial court, we had some capacity to do video proceedings, primarily with the jails, although there wasn't a great deal of uptake. Both counsel and accused persons at that time, before the pandemic, preferred to come into the courthouse. That's certainly changed now, where all matters involving bail are heard virtually. Additionally, there were some matters that involved vulnerable witnesses, so there was the use of CCTV. But again, not all courtrooms in all of our courthouses were fully equipped to be able to use this. So most of the technology that we have acquired and learnings that we have acquired have really been pandemic driven, with virtual appearances both for counsel and for the parties. There's been quite a learning curve, I would say. We started out with Skype. That was at the end of its life. There were issues with reliability and user experience. We then moved to Teams, and there was a lot of training required both for judges and for counsel. And then there was the hybrid experience of some folks in the courtroom, some folks on a virtual screen, some folks on telephone. So it certainly was and continues to some extent to be a challenge, although I would say for the most part, and I'm very proud to say our judges are becoming very comfortable with the use of virtual options. So bottom line, I guess, where there's a will, there's a way. In the past, I've heard from the powers that be that it couldn't be done. There was no capacity to do it. There was no money to do it. But when there is a pandemic, good communication, collaboration, and protocols, lo and behold, you can get things done. And in terms of what the response has been from both the council and the public, I would say it's been a mixed response. Like anything else, there are council and other participants in the system who are quite familiar and comfortable with technology. Others not so much, but really it's about access to justice and providing a more human-centered user experience approach. So I think I'll leave it at there for the time being, and won't go into the sort of the nuts and bolts of the actual proceedings that we undertake at this time. Perhaps we can come back to that.
Justice Grosse, the view from your court?
So very similar to Chief Judge Williams, our court was largely a in-person and paper court prior to the beginning of the pandemic, the odd exception for a phone application or CCTV appearance, but that was really it, both in terms of procedurally, the way we did things, and also in terms of the technology and the infrastructure that we had available. The government had pre-pandemic allocated a budget for a project we call Justice Digital, but the project was still in its infancy when the pandemic hit. So there had to be some really rapid improvisation to allow the court to even keep functioning. In particular, the two big areas you've already hit on, we had to develop some sort of virtual hearing capability, and we had to develop some mechanism for receiving documents other than people lining up in person. The positive was that the absolute necessity probably drove that Justice Digital project along faster than it otherwise would have gone. It was suddenly on the front burner for everyone. Also, I think it was easier for people to provide feedback and input into that process as it was developed, because we had this lived experience of what was working and what wasn't working, rather than just imagining what it might look like. I'm not going to take the time to go through the whole Justice Digital project and all of its very components, but basically, instead of purchasing an existing product, like I know Case Lines is being used in some jurisdictions, the Alberta government opted to go with more of a custom development using these small teams that concurrently develop different modules, which in turn, at least in theory, can then be sort of linked together to provide a whole suite of integrated applications. And that initiative spans all 3 courts in Alberta. For our court at the Queen's Bench, the key initial projects at least have been trying to gradually move from email filing, which is what we implemented at the beginning of the pandemic, to true e-filing as much as we can. We've also developed a new surrogate system, which is probably going to launch later this year. And then we're in the process of piloting right now a commercial case management system, again, with the idea that those will all use that technology to expand into other areas and eventually into the other courts. And then at the same time, we transitioned to M365 so that we actually have cloud capability. I would say generally the feedback from council and the public has been generally positive in the sense that we're moving in the right direction. There have been a lot of frustrations in the interim because, as I said, we didn't really have the infrastructure to do many of these things. So, for example, we had no storage capacity to store electronic files if they came in. We had no electronic document management system, which many businesses had already had, I would say most probably. So when the clerks started getting files by email, they were actually getting them by email, but then printing them for the paper file and processing them in paper, which actually made it longer wait times. So there have been a lot of frustration, same with we didn't have the bandwidth to be hosting WebEx and that sort of thing, even though we were using it. So there were tons of crashes and all of those sorts of challenges. So I know that there have been a lot of frustrations, but generally people like that we're moving to more digital and online solutions. And the bar has been very supportive in terms of helping us pilot some of these Justice Digital modules. So I'll maybe leave it there because I know there's lots of other things to talk about.
Yeah, I think there's a lot that we can revisit. Justice Kenkel, the view from Ontario?
Well, very similar. Maybe go back to just before the pandemic. You know, I took a look at the Auditor General's report in Ontario in 2019, right before the pandemic, because it happened to, the auditors happened to turn her sights on the courts. And she noted that pre-pandemic, in the months before the pandemic, 96% of all documents filed in Ontario courts were filed in paper. And that, I think, in one statistic gives you the picture in Ontario, which I'm now hearing was not really different in much of the rest of the country. We had many processes that were used virtual technology, bail hearings, et cetera, but it was really the pandemic that changed everything for us. I've been on the fact that everything is still in paper is somewhat hard to understand, because many of you, some of the older folks at least, will remember that back in the mid 1990s, 1996, Ontario had an integrated justice project. There were 220 some people working on Bay Street in a specific building that was set to fully digitize and modernize what we do in the justice sector for criminal, civil, family. And that was one project, a massive project that didn't succeed. There were others. I've been unfortunately part of all of those, either as a lawyer or then shortly thereafter as a judge. And I could tell you there's a history of failed stop and starts for many, many reasons. That'd be a much longer story, but it's not for lack of trying. Having said that, since I do have that overview, having been at that table, I can tell you that 90% of the technology change in Ontario's courts have happened since March. That March pandemic was identified within the last 2 years and really within the last 18 months. So as Justice Williams said, the first thing was the virtual courts. Could we operate? How can we function when we can't have people in the courthouse? And we had rampant COVID throughout this time in Ontario. So we had to solve that issue first, and we did the same types of things. We did audio proceedings first, then we went to Zoom as the quick fix, et cetera, and we're still using Zoom. But we realized almost immediately that that's just one aspect, that you really can't operate in a virtual environment unless your processes are electronic. So we've been doing a number of these things. As you know, we've adopted case lines for the Superior Court, Queen's Bench, and other provinces, and for family proceedings in the Provincial Court. I should emphasize that that is an interim solution, that there is a competition ongoing, and a vendor of record has not been chosen. So it may be case lines, it might be something else that's like case lines, but we are going to that. But we are digitizing also every other process that in the courthouse. There, we will convert every paper procedure that we have to digital processes. We have 4 or 5 ongoing projects, and many of them, as Justice Grosse said, are being done in-house. Everything from Frank, Icon, all of our record keeping, everything is being changed. So we have lots going on all at the same time, but it's really maybe the only good thing that came out of this pandemic is this complete revolution in what we do. But I'm really glad to hear that 51% of you, at least the slight majority, think that it's better. In my view, we can identify things that will make life better for judges and lawyers and our clients, our customers, as it were, going forward using digital processes. So I hope that we have that conversation as well.
Great. It's interesting to hear the overview, and I know a bunch of you have touched on a range of things, including things maybe we don't think about, such as infrastructure and bandwidth. But the most obvious change that I think most of the participants have experienced is the move to virtual hearings and remote participation. Justice Grosse, can I start with you? What is the current situation within your court in terms of the use of in-person versus virtual hearings? Is there any requirement to meet in person? Is there any direction the court is moving generally?
So at this particular moment in time, our default is still that everything is virtual except proceedings that require viva voce or oral evidence. That is still, sort of what I would call pandemic legacy, because we are still experiencing, a number of challenges in that regard. The court, though, had established a committee that looked at all of our different processes and where will those go coming out of the pandemic now that we can do things virtually. That is sort of in its final stages, and it was using the work already done by, I know there's been a number of public committees, the Canadian Bar Association, the Advocate Society, a number have had, and they took at all that and then looked at how it would apply in our court. So I expect that as soon as it is deemed safe to do so, a number of our procedures will go back to being default in person, but with far more flexibility than we had before to accommodate virtual appearances. I also expect there will be a number of our types of procedures that will stay default virtual, our family docket court, for example. So there's going to be, I think, a far bigger range in terms of default proceedings, and then a far greater flexibility even from those defaults in any particular case. I know what is not on the table right now is complete customization, any type of proceeding can be asked to be virtual or in person at any given time. And that's simply a resources issue. We just don't have the resources to react that quickly to, and the way our scheduling works doesn't work that way. But you'll see a far broader spectrum of options than were available pre-pandemic, and it will not be all virtual in our court, I am quite certain.
Now, you mentioned that it's all virtual right now except for viva voce evidence. Is that an organizing principle, a fundamental principle around which those decisions will be made? I mean, I'm trying to ask, in your view, is there a situation when it is always necessary or preferable to have an in-person hearing?
So, Eric, I think that that's something about which reasonable people can disagree. And I think you would get different feedback from different people. I think there is a strong thought by a large number of council judges and other participants that the preference for any viva voce proceeding, particularly ones where credibility is an issue, would be held in person. But I wouldn't say that that's a universally held view. I think there are others who feel that viva voce testimony can quite effectively be taken virtually with the proper security safeguards in place. For example, if you look at people who do big arbitrations, it is far more, and those can be have huge consequences for the parties and involve credibility issues. It's not uncommon for them to take evidence, viva voce evidence, and cross-examine virtually, and some of them have been very, very successful. So again, I think I wouldn't say it's a universally recognized principle, but I would expect, at least in our court, and I don't think we're outliers in that regard, that most viva voce evidence will have a default in-person requirement, but again, with more flexibility than there ever was before for an out-of-country witness or whatever the case may be.
Chief Judge Williams, can I turn it over to you, the view from your court on in-person versus virtual?
Okay, so the situation in Nova Scotia has been that we've have ebbs and flows of COVID, and so there have been 3 distinct periods of time, upwards of a month to 2 months each, where we closed the courts to in-person proceedings, but still held proceedings, some proceedings virtually. We're at the point now where we've got people coming back into the courts to have matters heard in person. Primarily that will be for trials and some sentencings, especially sentencings that may lead to custody. A lot of other matters continue to be done virtually by virtue of our courtrooms, many of them being small, and we're still trying to, in Nova Scotia at least, all levels of court have agreed to continue masking and the physical distancing to try and curb the spread of COVID. And so we're still trying to keep the numbers of people in the courts down. Even during periods where there were no in-person proceedings, there was ability and some capacity and some interest in doing matters virtually. When I say matters, I mean both sentencing matters and trials, although I would say that the number of matters virtual trials proceeding has been very low. Our court has been quite cautious in this regard, but taking into consideration necessity and risks associated with virtual testimony. So I wouldn't say that it doesn't happen. What I would say is that it does not happen often, but that virtual proceedings are used on a regular basis for procedural appearances, for bail hearings, consolidation sentencings, resolution conferences, and the like. The other aspect of, and it's a virtual proceeding, but it's not a court appearance, is we heavily encouraged and developed a process for e-warrants to limit police from coming into our court facilities. And as Justice Kenkel said before, I think all of us were experiencing a court system that was primarily, if not exclusively, based on paper. And now we've developed some means of being able to do some of our warrants by telewarrants. We're very hopeful that the proposed changes to the criminal code will be enacted because they will allow for wider discretion for use of things like e-warrants, but also will provide further guidance to the courts and the stakeholders in terms of what types of proceedings can proceed virtually under what circumstances.
You mentioned as one of the factors that you look at with the return to in-person, the risks of virtual testimony. Can you expand on that? What are some of the risks?
Ensuring that an individual is in a private space. There's no one that is near them that can influence their testimony, that they don't have sort of testimonial aids at their disposal, notes that they've made or that they're referring to. So as close as possible, we're trying to replicate the experience that the witness would have if they were actually in the courtroom. And sometimes that's difficult to assess in a virtual proceeding. I would say that it's really important at the beginning for the judge to sort of set the ground rules in terms of what's acceptable and not acceptable, in terms of privacy, security, and even decorum.
Justice Kenkel, the view from
In terms of, I should maybe just go back to the last question quickly. Presumptively, as of March in the Ontario Court of Justice and as of April 19th in the Superior Court, particularly in family court proceedings, hearings are presumptively in person. That is subject to the agreement of the parties and applications in the criminal context, as Chief Justice Williams just mentioned. So they're presumptively in person. Having said that, 80% of hearings that we are doing right now, even now, are on Zoom. In the family context and civil context, it's almost 100%. So we are largely in a virtual environment, and that will be so for a little while. I was just looking at a case, and when I look away, I'm just looking at another screen. But the family court direction came out April 19th, so a couple of days ago. There's already been a case. Cousins, spelt as it sounds, versus Silborne, Salbourne. I don't have a site because there isn't one yet. But this Ontario Superior Court, an application where a lawyer had COVID. And there was a family court settlement meeting, settlement conference, I think they call it. And both parties agreed that because the lawyer actively right now has COVID, that the matter could be done in a virtual way on Zoom. And the Superior Court judge presiding ruled that that's not possible. That wasn't a sufficient reason, and instead adjourned the conference hearing to 1 month to a May date, so it could be heard then. So lawyers, just a flag to the lawyers that it may not be that the consent of the parties in all cases is enough to simply set aside the presumption in the Superior Court, at least, of attendance in person. So that's where we're at. In terms of security, one thing I'll just add on that point is virtual proceedings, as effective as they have been, they've been remarkable, and we've used them for a year and a half in every possible type of proceeding. They do come with their own issues. So as an example, there was one hearing that I had where it was a preliminary hearing, but there were undercover officers from the Toronto Police Force coming up to the York region to testify. And on Zoom, they worried about exposing their identity because, believe it or not, in Ontario, there are 2 websites that seek to expose the identity of police undercover officers across the province. And the Crown made an application, which I granted, that allowed these officers to wear COVID masks to conceal their identity, because we're all aware that despite the Courts of Justice Act warning that we start our proceedings with, that it is very simple for anybody to just by a click of their phone or taking a screenshot on their computer, anybody can take the picture and disseminate photos of people testifying in a way that you never could do in an in-person proceeding. So there are things that are unique to that context that, other new issues arise. So it's not everything that's better on Zoom, but it's been remarkable how many cases, including cases where the only issue is credibility, that have been done effectively on Zoom.
So would you say that the presumption towards favoring in-person hearings still, is that based on some of these security and logistical issues, or is there an underlying concern about assessing credibility, which we've heard in other places?
Well, just for me, it's not credibility. People forget that judges have been assessing credibility in this context for a long time. For over 20 years, many of our child witnesses, our vulnerable witnesses in sex assault cases, have always been remote. For the trier of fact, they've always been on video. And so, second of all, what people often cite in that argument is issues about demeanor. One has to go back to current Court of Appeal and Supreme Court instruction on demeanor. Demeanor plays a very, very small, if any, role in the modern assessment of credibility. So it's not really a reason. But if you are interested in demeanor, here's the last point. Guess what? They call it Zoom for a reason. They call it Zoom because you have a very good upfront, intimate picture of somebody speaking, like usually the speaker, the camera focuses on them. You, in most cases, have a better view of the witness as a judge than sideways from somebody beside you in a courtroom. It's an intimate picture. If there are any aspects of demeanor, you would be more likely to capture them on Zoom. The reason people prefer in court are good ones that really, what the Chief Justice mentioned, is security of the proceedings. We know where the witness is. They're not being influenced by outside people. And there's a solemnity to it that has frankly slipped We can talk about that later about best practices, but there's a solemnity that is consistent with the gravity of the proceedings that is present in person that may not be present if you're doing your Zoom trial from your washroom or your car.
Well, let's get to that. I think best practices for this audience may be something that they'd love to hear. So the view from the bench, maybe I can go around to each of you, sort of top 1 or 2 tips for litigants or counsel appearing before you virtually. What works, what doesn't work, either do's or don'ts. Justice Grosse, start with you.
Well, they aren't actually very exciting tips, but they're very practical, I think. So I would say one of the biggest ones is not so much relating to the virtual appearance, I guess, but would be, I think there's a much greater need and emphasis now in thinking ahead of time on what records and materials you need to have in front of the court, because the old pass them up is not either not available at all or is not as handy. So I think there's a greater onus now on counsel to think about what might I need, and not just the materials for that particular application, but maybe is the judge going to have to look at the statement of claim or some other pleadings or a past affidavit. I think there's a common misperception, and I don't know how it works in other jurisdictions, but there's a common misperception in our jurisdiction that I can somehow just look that up, and I can't. It is not available to me unless you have provided it. And I guess the corollary to that would be, if something comes up, because we all know it does, that you didn't foresee, or for some reason you submitted your materials and they haven't made their way through to the judge, which has been a very frustrating experience for all of us, at least in our court, is have a scanned copy ready on your computer, ready to go, so that if someone gives you a link or an email, you can deal with that very quickly and we can try to keep things moving. I guess the second would be, and I actually personally haven't had a huge issue with this, but would be the decorum piece, which Justice Kenkel has raised. There has been, I know, enough reports from my colleagues that I believe it's a real thing about the lack of decorum, people showing up with a big coffee that's spilling over, they don't have the same clothes on that they might otherwise be for court, and also counsel not preparing their clients in that regard. So you have clients in all sorts of places, in all manner of dress, people walking around their house on their phone while they're talking to you, and we want to make things accessible, but on the other hand, there is a seriousness to this that can't be lost. And like I said to someone one day, going to court and getting a ruling on your parenting time with your children or whether you're going to go to jail, we want to make it accessible, but we don't want to make it the same as buying a pair of socks online. There has to be something, the gravitas of it has to be conveyed, and to the extent that counsel and parties can help us do that in the virtual setting, that makes the virtual setting more usable.
Chief Judge Williams, I see you nodding along to talking about decorum. Any thoughts on that, or any other tips for people appearing in front of your court?
So tech checks, as we've realized this morning, are essential. But even with tech checks ahead of time, things can still go wrong. So I think we all have to be mindful of what is plan B if the technology doesn't work on any given date, or a member of the or participant in the court session is having technical issues. So that's something that at times is beyond anyone's control. I don't know about others, but there are times when, for no reason at all, my screen might freeze or my camera won't work, despite the fact that 5 minutes earlier, everything had been fine. So that would be one point that I would add. I don't want to repeat anything that Justice Grosse has said, but I do agree with her points. Being prepared in all respects is absolutely crucial when doing a video or a virtual proceeding hearing.
Yeah, and I know we've had a few tech hiccups even with this session, so I think that really hits home with us. Justice Kenkel, I think you raised it. I want to come to you for a couple of tips from your experience.
Justice Grosse, right off the bat, and Chief Justice as well, mentioned it. It's good to be, prepared. But remember that starts at the case management level of proceedings. So before you enter into the trial or even right into trial preparation, you should be discussing at the case management stage of a judicial pretrial meeting or the equivalent in your province is held, what technology, if any, is going to be used. Is this something we could do by Zoom? Is everybody okay by Zoom? Is it going to be hybrid? Hybrid proceedings are very tricky. There are technological issues. And so is this something we could do? Is the jail okay with, are they going to have a video booth that they can put this person in for the whole day and that they don't need for pleas? And there's a lot of things that you need to walk through, but you have to walk through your case. And as Her Honor said, Justice Grosse said, how am I going to present this evidence? How am I going to tender this? Where's it going to go? Because the courts are not yet fully digitized. We will have digital platforms where everything will be sent seamlessly, but until then, where is it going to go? So all the courts have been doing, I'm well aware, we've been doing all sorts of hacks to get around this issue. We've been putting materials in judicial calendars and slowing the system down to mud because we are using them for ways they're not intended to be used. Well, we all have reasons, ways to do that. But think about how you're going to operate in the virtual environment. The other thing that's really important is to treat it like a court. You're not Trevor Noah. You don't get to show up to work in a hoodie and have your home background. Think about a professional background. Make court like court. As you see the judges doing, we have our own backgrounds. We make sure that court looks like court and we treat it like court. The lawyers really have to do the same thing, or we won't have this ability at all. There's a lot of tips that I could go through, but those are really the central ones. One little example, though, people find hacks that they can do to make life easier, particularly in quick case management courts or set date courts. You'll see lawyers come in, they'll do a quick version of their name plus the line number plus the accused name, and they'll do that, use display name function to communicate info. Then as soon as a matter is completed, if there's an order to be signed, you'll see the lawyers changing their names to their email, so that the clerk can immediately get that and email them the order. There's things you can do in the virtual environment to make life easier. So make sure you pick up on those tips, notice what other people are doing, and it'll speeds up the process for everybody.
I think those are great, and I think that's something that our audience loves to hear directly from the courts and from this review. So zooming back out from the hyper practical to high level again, and Justice Kenkel, I'm going to stay with you for this. Can you talk about the impacts of all of this technology on the administration of justice issues, things such as access to justice or judicial backlog? Has there been a net gain or positive there, or are there some challenges remaining?
Well, I think there's been a net gain in the sense that if we had only in-person proceedings for the last 2 years, we wouldn't have been doing any cases. Our province has been shut down for a long part of those 2 years. So the net gain is plain in Ontario, at least, and I think it's similar in other provinces, that this has allowed us to do business as best we can in a virtual environment. But going forward, we learned a lot of things. Here's an example of how access to justice in a way is improved. An Indigenous person was arrested in Newmarket, far from home, and he asked for his counsel who knows him best. He was in custody. He said, there is a lawyer who knows me and my family and my reserve where I grew up. He's up in Hearst. Hearst, Ontario is 10 hours away from Newmarket. It is in the far north of our province. If you drove 10 hours south from where I'm in Newmarket, Toronto area, you'd be in Virginia. So that gives you a sense of how far away it is. We emailed his lawyer on the off chance that would be possible, and the next day the lawyer appeared via Zoom. He'd never appeared in a court in the southern part of Ontario ever. We've had, the other day yesterday actually, I was in a court doing a trial in Newmarket, but they need an out-of-town judge to solve something in Peterborough, so I went in and dealt with the matter over lunch hour and came back. That's a 2-hour drive from where I'm at. Normally I would have taken the whole day off to do that, just to do that one thing for half an hour and then come back. There's a lot of efficiencies. We've had clerks in Newmarket coming from as far away as Ottawa, translators coming from great distances away. So we think that there's a lot of efficiencies. There are things, I think at the end of the day, we'll realize set date appearances, even case conference or judicial pretrial meetings that will be probably better done by Zoom. Nobody wants to drive an hour or two just for a 10, 15-minute meeting with a judge or to set a date. These appearances hopefully will stay virtual, but there are some other ones, even large cases. Let me just give you a quick example. A preliminary hearing last summer, it was a federal Department of Justice from Toronto came up, all sorts of charges. There were 27 people on the Zoom. It was a virtual proceeding. The accused parties were in Niagara region, Brantford, which is west of there, Hamilton, and Orillia, which is north of where I'm at. The police services involved were Niagara Regional Police, Hamilton Police Service, Toronto Police Service, and York Regional Police, where I am. Can you imagine all of those 27 parties? The places I'm describing, many of them are 3 hours away from the Newmarket Courthouse, just north of Toronto. Can you imagine all of them driving every day through the traffic of the country's biggest city, trying to get to this preliminary hearing? Or they could stay, who has money to stay, but they could stay up here. So that's one thing, is that everybody, I checked every day, and at the end of it I checked, everybody agreed that it was far better to do this preliminary hearing, at least, on Zoom, and it worked well. Here's the other thing that surprised everyone. It was scheduled for 8 weeks because it had charges, drug charges, firearms charges, murder, conspiracy charges, all sorts of things, scheduled for 8 weeks. We finished in 4 weeks. We weren't rushing. Zoom, it's generally been the experience, is a far more efficient platform than in-person trials. So again, I'm not an advocate for everything being on Zoom, but Zoom has efficiencies that really help the justice system. We gave back 4 weeks of trial prelim time.
Follow up to turn over to Justice Grosse, just asking whether she shares the view that there have been logistical gains in doing things remotely, and then on the flip side, have there been any challenges that you've seen with people who don't actually have access to technology? Because we've heard some concerns.
So I think there are pluses and minuses, and we have to be sensitive to all of those. So I'm not going to repeat everything Justice Kenkel said, because I agree wholeheartedly. I mean, when I first came to the court, it made zero sense to me that people had to, say, drive in from Okotoks, which is just outside of Calgary, take time off work, pay parking, expensive parking downtown, all to come in for a 15 or 20-minute appearance. I just couldn't get my mind around why that was happening. Similarly with the paper documents, and unfortunately this is still the case for our self-represented people right now in Alberta, they have to physically attend at the courthouse to file documents. Well, that can be a hugely expensive undertaking for someone, because they have to come in business hours. Again, they have to pay parking or go on public transit, etc. On the other hand, and this has been raised many times, and it's not lost, is that there are people who don't have access to technology and reliable technology. That's an issue, and we can't forget that. There also are people who benefit from coming to the courthouse because maybe the way that they communicate, or a particular health challenge they have, or other learning challenge they have, is better dealt with face-to-face with someone who's explaining a procedure to them. Or they have trouble digesting the material that's available online. They have trouble dealing with forms without a little bit of assistance, and traditionally those services have been better available in the courthouse. So there's no question that we have to be cautious in terms of making sure that for people for whom the technology piece is a struggle, that this doesn't become a barrier to justice for them. That said, though, I think for all of the reasons Justice Kenkel has outlined there, it does actually offer the opportunity to improve access to justice for many people, including potentially having a lawyer when they couldn't otherwise afford to have one, because the lawyer doesn't have to travel or something like that.
Chief Judge Williams, can I just ask you for your experience as well, but also a comment on whether these efficiencies that we're seeing, if that's had any impact on judicial backlog and delays and all of those concerns that have gone back pre-pandemic concerns.
Sure, thanks. So I agree wholeheartedly with the previous comments made. To me, you know, the whole question of access to justice is looking at it from the user-centric perspective. And for too long, I think our system has served the system users and not the public who are using the courts. And so when I look at what is a better option for someone, they're best able, I think, to determine what is best for them. So a mother that has childcare issues who has a quick appearance in a court is certainly better served by a virtual appearance if there's the technology, if there's the internet connection, et cetera. If there's someone with transportation issues, similar. Certainly the costs of engaging lawyers to appear personally and bill their time for transportation, a simple virtual appearance will be much more cost efficient for them. So really it depends on the circumstances of the individual user. Two other points. In terms of efficiencies, during the pandemic, the chief judges and justices of all the provincial and territorial courts in the country agreed to put a system in place, and we're still working on it. But basically, we're helping each other out. So there's a trial here in Nova Scotia, which involves a witness from Fort McMurray. Not unusual. And so, you know, I've pick up the phone, call the Chief Justice in Alberta and say, Derek, is there some way that we can manage to have so-and-so appear at certain courthouse on a certain day at a certain time to give evidence? And you know what? It's always happened. So I think the pandemic has enabled us as leaders to try and facilitate interprovincial accommodation for witness testimony, where in the past there was just too many hoops to go through. Secondly, we have had a shortage of judges here in Nova Scotia, which means we've had to collapse dockets. So in some instances where we've had rural dockets in two different, maybe opposite ends of the province, we've been able to have one judge virtually do both dockets, you know, in a docket in Yarmouth and a docket in Antigonish, all on the same day without having to leave. So that's certainly been a plus. But given the, and I don't know what it's been like in other provinces, but with the workforce shortage, both in terms of judges and lawyers, crowns and defense and court staff, we've really been battling with trying to attack backlog in that regard. My hope is that virtual proceedings will be able to be used in the future to move bail hearings, consolidations, and things of procedural nature, perhaps physically out of our courtrooms, so that judges and court staff and lawyers can appear virtually and leave our courtrooms for places where we're actually scheduling trials and hearing viva voce evidence. We haven't quite got there yet, but hope is still there.
You mentioned something really interesting about the interprovincial, interjurisdictional cooperation. Obviously, there's been a lot of change across the country. Is there something more formal than the Chief Justices calling each other? Should there be, if there isn't?
Yeah, we're sort of at the point now where I've made a number of phone calls. I've always been accommodated, but I've said to them recently, we really should be developing a protocol to identify who, you know, from a court location is the contact person, so that we have, you know, an email address, a telephone number of somebody from each of our court locations around the country, so that when the need arises, court staff can do it, as opposed to Chief Justices having to try and facilitate it. So it's a work in progress, but I'm confident we'll get there.
Justice Kenkel?
In some ways, in the old days, when the technology was more focused, you had to make these special arrangements. Even within Ontario, we had to do it. But now, you just send somebody a Zoom link. So just as an example, 2 weeks ago, I was hearing provincial offense appeals, which is something our court does. One of the appellants was arguing from Israel. And I immediately took the view that her attendance in the virtual court in Ontario was sufficient, particularly for a provincial offense appeal. But you really just send them the Zoom link. It seems like things have gotten a lot easier. Although I didn't know about this judicial issue in Nova Scotia. If you have anything coming up in like a Lunenburg, say, anything South Shore, just let me know in advance. Just give me a few weeks advance. I'll get the resume.
Eric, can I just add a couple of things that build on those comments? One is I'm going to get the name wrong, but there is an official working group through the CJC, so the Canadian Judicial Council, on technology related matters. And I can't get the name right, but I believe actually Chief Justice Morrow of our court may chair that. The second piece, though, that I just want to throw out there is, in our court, one thing we do is we call them either ISOs or IJOs, which is interjurisdictional support order hearings, which has traditionally been just a really frustrating process, I think, for everyone involved. So you start an application to vary support in one court, and that judge can hear evidence, and then you get a transcript of that, and it gets sent to another judge in another jurisdiction who does a review, all based on the idea that these two parties in two jurisdictions couldn't participate in the same proceeding at the same time. And there's legislation around that, and I can't change the legislation, but I'm throwing this out there as it seems to me that now with the virtual capabilities, that whole legislative regime probably could be reviewed, because there's probably no reason why we can't just deal with this in one court at one time for everyone and get it done, because those can have huge delays, I know, through all of those steps. So it's just a good example of where this could really, things like this can really, really help people.
It sounds like we're unearthing sort of new opportunities all the time with the technology. So just sticking with you, Justice Grosse, the last topic I wanted to cover today was obviously been a lot of new technology, a lot of opportunities, but change management and sort of adoption, not only by the bench and the courts, but also by the bar. Has the standard been raised for technical competence of lawyers? And if so, how has that challenge been met by the bar? Has the standard of technical competence been raised for counsel appearing before you? And if so, how has that been addressed by the bar? Have they responded well to it? Have there been challenges?
Well, so overall, I would say the bar has responded very well. I think it's there were bumps for everyone at the beginning, on not just in the legal world, all worlds, and we can all think about the cat filter and all those sorts of things, right? But I think generally I have seen the ability to deal with the technology, the virtual setup, the technological infrastructure improve for everyone as we went along, because I think people have been really willing to invest in some, a new camera or a new ring light or whatever they needed to make it work. I think we in Alberta have had enormous support from the bar in our moving to some of our online filing tools and that sort of thing. And I think that generally I get asked a lot about virtual advocacy, and there are some things to talk about there, but generally advocacy is advocacy. And I think we've still seen very good advocacy in the virtual context. I don't take any issue with that. So I think generally everyone's done well. From the court perspective, you have to remember that in the courts, oftentimes we have a more aging workforce than a lot of other workplaces. And even there, I think you've seen judges that never really used a computer at all who are really jumping in and adopting this. And again, I've seen this with counsel too. Counsel who would have come in the courtroom before and said, I don't have my calendar on my phone, I only use my agenda, so we have to phone my assistant to get my schedule. Those are now people who are participating in virtual hearings. So I think everyone it hasn't always been smooth. There's been a lot of what I would call MacGyvering. That's probably a reference that's too old for most of our audience, but I think everyone has worked very hard to try to make things work, and now is working very hard to say, what have we learned and how can we build upon this and use it to everyone's advantage going forward?
Chief Judge Williams, can I just ask you along the same lines, what are some lessons or experiences learned over the last couple of years in terms of communicating rules and procedures to counsel and then enforcing some of those new rules and procedures?
Well, first lesson learned, I think, is that, as I said earlier, when faced with a dilemma, you look for ways to try and resolve the problem in new and creative ways. In our experience, it's been really important to have good communication, collaboration among justice system stakeholders. I'm just going to take a drink of water. My voice is leaving me. So although we are all independent entities in a criminal justice system, the one that I work in, we're also interdependent. And so there's that need to be able to understand the business needs and the business practices of each other. I think the pandemic has forced us to be more nimble, more creative. My fear is that we're going to slip back to the old traditional ways of doing things. But I think that we've established some pretty good protocols and practice directives, and certainly in business improvement ways of proceeding. Should there be new rules and procedures, and do they need to be enforced? And if so, how? My experience has been that the best way to lead is by persuasion, and that you encourage people to come along with you, and that you don't get very far by, taking the a tough approach with an iron fist. So respectful direction by counsel or by the judges to counsel, I think, and persuasion is a much better way to proceed than embarrassing or coming down hard on counsel, particularly in courtrooms with their clients with them. The other thing is to identify champions and to encourage those champions to come forward and to bring others along. And generally speaking, some are more willing than others to come forward in the beginning, but others follow suit. So as Justice Grosse says, we've had some of our retired judges who are now working part-time who thought they would never do a matter virtually, who are now saying, wow, especially for procedural matters, this is great. And I'm glad that we're doing it. So.
Great. So Justice Kenkel, I want to turn it over to you and your thoughts as well in terms of the change management, but also since we're getting to the top of the hour, if you had any sort of final thoughts as well as we wrap up this session, either I know the audience would appreciate more practical tips or a quick vision of the future as someone who's very close to all the planning for the Ontario courts. Some final thoughts there.
So I think that particularly for the younger lawyers, I'm in more sort of the north end, the later stages of a career than the beginning. But if I were in the beginning, I would focus on this, and it's Richard Susskind's quote from his virtual court book that came out just by coincidence just before the pandemic. But he sort of reminds us that justice is a service we provide. It's not necessarily a place. And I think that if there was any doubt about how technology would play a role in our practices and in the future, it was solved right off the bat in the pandemic days by the adoption of virtual technology, and also the Superior Court commercial list early case of Arconti and Smith. I put the link up, or the site up, where a justice there, I think speaking to a matter on the Toronto commercial list, but they're already heavily technology focused, said essentially, we're no longer recording evidence via quill and ink. So it's not been my experience that the age is necessarily a good predictor of technology adoption. Maybe that's because I'm in criminal court and we have a lot of people who, have not had much experience with technology and tried to minimize it, but the ship has sailed. Everything in this province is becoming digitized. You will not be able to file paper documents. Already those in the Superior Court and in the Family Court and those are already digital processes and being converted. So prepare to operate in a digital environment. The good news is we're information processors. We're catching up to every other information processing business where they were in the 1990s. And you'll find your job gets much, much easier when you operate in a fully digital environment. This is made for what we do. We're certainly concerned about making sure that, particularly in criminal court, which is where I preside, there are some folks who don't have access to technology and need help with other aspects. But if we can take 95% of the people or more out of the equation, then that's doing a real service to others who just need the paper filing and everything else. We speed up their processes by a lot. And it's been remarkable to me how few people really have had an issue. We expected more with technology, not having access to technology. Part of that was the riddle or the mystery of McDonald's and Tim Hortons. Because I don't know if other people noticed at the beginning of the pandemic and throughout the pandemic, a lot of people were appearing in, especially in set date courts, from McDonald's and Tim Hortons. And literally, as a presiding judge, on a set date court particularly, the name would be called and he goes, hang on a second, I said double in a Dutchie, Your Honor, these people. Why is that? And then we finally realized, after discussing it, locally, that people don't have bandwidth. Not everybody has bandwidth. A lot of people are sitting right outside the Tims for the hour and a half that it takes to get called in a 500-person list because they need the bandwidth. And after that, the judicial, temperature went way down when we understood why these things are happening. It's remarkable how few people have had better access through technology, but it's not the solution for everyone. I would mention one thing that Chief Justice mentioned, Bill C, I think she was referring to Bill C-23, sort of the cleanup bill that was meant to clean up the criminal code changes. I see there's a number of criminal lawyers, I've seen in the names in the chat. So Bill C-23 was meant to clean up inconsistencies when Parliament, just before the pandemic, introduced Bill C-75 and passed that. So that's your section of the criminal code 715.1, the sections north of there, that provided for virtual hearings. It wasn't done in the anticipation of the pandemic because it was September before the March pandemic. Just happened to be lucky. However, when they did it, they left legacy sections from 25 years ago that conflict. So Bill C-23, as the Chief Justice said, was meant to correct that. Bill C-23 died on the order paper when they announced the election, the federal election in the fall. So it is no longer before Parliament and it has not been reintroduced. But just for people in the criminal world, if you check the Senate Bill S-3, Senator Mark Gold, Osgood folks might remember, he used to be a prof there. Senator Gold has reintroduced Bill C-23 as S-3. So we're really hoping, all of us, that it could come back in because it addresses many of the issues that Her Honor mentioned.
Well, that's great. Thank you very much. I think we're going to have to leave it there. I know we could continue this conversation with you for another hour, but that's all the time we have for today. Thank you so much for taking the time to have this conversation with us. I know our attendees really enjoyed it. And thank you to all of you for joining us this afternoon.
Thank
Thanks,
you.
Eric.